to Making Civility Your Superpower. I'm Lori Cripp Martin, the past vice chair of the Beverly Hills Bar's litigation section and a certified family law specialist. I'm delighted to introduce our speakers, Joanne Rezzo and Judge Kenneth Medell. Joanne Rezzo brings nearly 30 years of litigation experience and a dynamic, high-energy personality to Signature Resolution's panel of neutrals. Known for her balanced approach, Joanne represented both defendants and plaintiffs at trial, giving her the advantage of being able to truly understand both sides of every case. Because her litigation career was split evenly between representing defendants and plaintiffs, she understands each side's unique perspective and knows how to unite parties to achieve a resolution. She brings the same level of detailed preparation to each of her mediations as she did to each of her cases that she took to trial, often preparing her own detailed chronologies, weaving together facts and evidence from each side. The Honorable Kenneth J. Medell brings 14 years of judicial experience and 23 years of civil litigation experience as a trial attorney to Signature Resolution's neutral panel. With this extensive involvement in civil law and a virtue of empathic listening, he enjoys an ability to effectively communicate with parties and attorneys to achieve meaningful resolutions to challenging disputes. His mediation philosophy is centered on a comprehensive understanding of the unique circumstances of each case and the importance of respecting the positions of the parties and attorneys with equal care and consideration. And now let's get started.
Thank you very much, Lori, for the introduction. Judge Medell, do you want to start the?
No, I just want to say it's a great honor to be speaking to the Beverly Hills Bar Association, because every lawyer that ever came to me in San Diego who was from Beverly Hills had to say, I am from Jones and Smith from Beverly Hills. And I always enjoyed and wondered why that happened. And I'd always say, well, I'm Judge Medell from San Diego. So it's good to meet you all today. And I think we're going to just start with those introductions and that comment. We're going to start right into our program here. It's mostly on PowerPoint, so I hope you enjoy it. Here we go. This program is called Making Civility Your Superpower, Superhero Power.
Superhero Power.
Okay. So we're going to start off with some definitions so that we can put our presentation in context for you. So the first one is?
So civility. It's formal politeness and courtesy or in behavior or speech. Generally, if you think of it this way, I hope we can treat each other with civility and respect. Now, some people think that you have to be an absolute bulldog at all times when you're litigating a case, but the reality is you can be an effective litigator, and I would say even a more effective litigator, and still be civil to the opposing parties in counsel.
Civility ties in with professionalism and is an integral part of professionalism. Professionalism is the competence or skill expected of a professional. And a nice vignette of it is that competencies and learned behaviors that help you perform your job to the best of your ability. Professionalism encompasses how you conduct yourself in the workplace, your communication style, your integrity, your work ethic, or how you handle conflict. So you can see those elements of civility are deeply embedded into the very concept of us being professionals.
So collegiality is defined as companionship or cooperation between colleagues who share responsibility. I'm reminded in this definition of an attorney that I was opposite on a case years ago now, but we took the case all the way through trial. And one of the things I'll remember very clearly from my relationship with her, she started every single email with good morning, I hope you had a nice weekend, that sort of thing. Then that set the tone for our relationship as opposing counsel throughout the case. And you can actually build good constructive friendships with opposing counsel.
Guys, with those three, and ladies, I always say guys includes men and women, so forgive me for that. But with those three definitions of mine, I want to ask you a critical question. That's kind of the theme of our presentation is, how do you want to be remembered when your career as a professional is over? And so let's give a few vignettes. First of all, I had a case. I did primarily medical malpractice when I was a civil defense lawyer. but some things were sort of related to medical malpractice, and those were slip and falls in the hospital. I had a case where a young woman um, was hospitalized or admitted to the hospital for diabetic problems. And on the first night she was in a room, she went into the bathroom and saw that there was water on the floor. So she told the nurse, there's water on the floor of my bathroom. The nurse called up the maintenance man and said, can you come and fix water in the bathroom in room 336? The maintenance man came down. He did a repair. The next day, the lady went into her bathroom and there was water still on the floor, and she slipped and fell and had a very serious back injury. Okay, so here's your first quiz. Once we got going with the case, the lady sued the hospital for negligence. Once we got going with the case, the plaintiff's lawyer, who was a young up-and-coming guy in the plaintiff's world, wanted to take the deposition of the maintenance man. Now, a couple facts. The only thing that the maintenance man had in terms of a record for this thing that happened years ago was a log that said water on floor in room 3102, tightened sink valve. That's all he had. And he had no recollection whatsoever of anything that had to do with this event whatsoever. So that's all we had. So my first question to you is, how long should this deposition take if he had no remembrance of this thing whatsoever, and the only thing he had was tightened sink valve?
1 hour.
I think 1 hour is reasonable. Well, the answer is that it took 8 hours. It took the entire day. Why did it take entire day? It took the entire day because the plaintiff's lawyer kept asking the same questions over and over and over. No matter how many times the maintenance man said, you know, I really don't remember, he just persisted. He put words in the witness's mouth by misquoting the witness's prior testimony and asked so many questions that required utter speculation that it just consumed the whole day. Here's the worst part. At a break in the deposition, the plaintiff's lawyer stood up, put his hand on my shoulder, and said in a very patronizing way, how am I doing, Ken? As if to acknowledge that all of his improprieties were intentional and not just lack of experience or inadvertent. So that started. Oh, and by the way, when we got to the end of the depo, he wanted another session, which I said, absolutely not. We're not going to do that. There's part 2 to this story, and that was the plaintiff's deposition. The plaintiff's deposition took place in a place called Escondido, north of San Diego, in a building that had buildings all around a square, but in the square, it was open to the elements. It was open outside. And it just happened to be the coldest, rainiest day of the year when I showed up with my briefcase to take the deposition. And I walked up to the door, which is a traditional door with a glass window in it. And I could see the plaintiff's lawyer and his client inside. And I knocked on the thing. And he put up his finger and said, wait. I got there 40 minutes early because it's quite a drive from my house, and stood in the rain and the cold for about 50 minutes, 10 minutes past the appointed starting time, waiting just to get in while he prepped his client. And the court reporter had to do the same thing when she arrived. When the deposition took place, when I came around to questions that were meaningful and substantive and maybe difficult for the plaintiff, he would obstruct the testimony. He would object and then say, Ken, did you mean to ask this? And he would recharacterize what I said to my question as something entirely different. He would change it into the answer or the question that he wanted. And oftentimes he would include the answer that he wanted in the question that he made. He would whisper in her ear. He'd say, before she answers that, and he'd whisper in her ear. And then she would have her answer after that. So it just appeared to be he was telling her exactly what to say. At a certain point in the deposition, because I was kind of well into my career, and I think he knew who I was, at least, he said, Ken, I think you're getting mad. Are you getting mad? And I said, I am. I'm getting very annoyed at this. And he goes, well, do you want to step outside? Now, he didn't say that like us men usually say that, like, let's go fight. He said it like, I want to know why you're so mad. And here's what I told him. I told him, do you watch professional basketball? And he goes, well, sometimes. And I go, well, I don't watch it anymore. And I don't watch it because every single time a guy is fouled, he has to argue with the ref. Every single time someone makes a mistake on the other team, they have to mock the other team or make fun of them. And they oftentimes get up in the when they just do something routine, they get up in the face of the other player. They call themselves professional basketball players, but there's nothing professional about what they're doing. And you, Mr. X, you have behaved extremely unprofessionally today, and at my client's deposition, in contravention of our obligation to act professionally as one of the highest professions in the land. And that's story number one.
That's a great story, and it's a lead right into a discussion I had with a judge that I worked for after my first year of law school. And I did go to law school in Los Angeles at USC, so I'm sorry if you're a UCLA grad out there. But I went to work after my first year of law school for a judge. I did an externship with Judge Rhodes in San Diego, and he taught a lot of wonderful things to me over the course of the summer, but one thing really stuck with me. And he said, your reputation is everything in this business. So your reputation is your stock in trade. And if you ever do anything to sully your reputation, you're never going to lose it down, especially in a town like San Diego, where everybody knows everybody. So you'll never remove the tarnish, as Judge Misdell's story illustrates it. He's going to always remember this attorney that was such a jerk to him.
That was 25 years ago.
Absolutely. And the other point that I make is you have to really consider how you treat the staff too. It's not just how you treat other lawyers, but how you treat the secretaries, paralegals, and other professionals in the opposing party's law firm or the judge's staff. Because as we'll talk about in a little while, they see it all and they hear it all. So aside from being the right thing to do, civility is actually really good for business. And one of the things that I found as a litigator, and again, Judge Midell pointed out, or Lori pointed out earlier, I actually represented plaintiffs for half of my career and defendants for half of my career. Sometimes for about 20 years, I represented both plaintiffs and defendants throughout the course of those 20 years. But the one thing that I found out was I got referrals because I was civil, because I was professional. I actually got referrals from an unlikely source. 50% of my referrals came from lawyers I had litigated cases against. So a lawyer's mother, father, brother, sister-in-law got fired, they referred him over to me. 80% of my good cases, the cases that we actually made real good money on, came from opposing counsel. I actually, when I transitioned to becoming a full-time mediator a few years ago, there was an attorney that I had 4 cases against, and he kept saying, I keep proposing you, trying to get you hired on a case, but we're going to do it. We're going to work together. So we finally had a case together about 6 months ago, and I do pre-mediation phone calls in all of my cases. And I had my phone call with him, and he said, well, Joanne, does the name of this client sound familiar? And I said, sorry, it doesn't, should it? And he said, this is the defendant where you represented the plaintiff in a lawsuit against this company about 10 years ago, and I defended the company in that case. And I was shocked. I was surprised. I said, wow, it must be a different in-house counsel. I'm surprised they were willing to hire me. And he said, no, it's the same in-house counsel. But because you comported yourself in a professional manner, they were fine using you as a mediator. I was actually hired recently to speak, or requested, not hired, but asked to come and speak at an employment law summit. Again, different attorney, but it was an attorney here in San Diego that I'd had 4 cases against, including a case that went all the way through trial. And literally just minutes ago, I got a retention notice for another mediation. Again, different attorney, an attorney I had litigated several cases against. And the defendant that he represents in that case is a defendant that I actually sued in a prior lawsuit. So again, civility is good for business, but let's talk a little bit about the consequences of incivility. So if you comport yourself in a way that's uncivil, There's been a recent study that reported that 92% of the people attorneys surveyed, that it doesn't actually enhance the client result, that attorneys who engage in civility actually get a better result. It makes it more difficult to resolve matters, and it's more expensive for clients. Think about all the time you spend dealing with issues that you wouldn't have had to deal with if you guys are getting along. What happened there?
Blackness.
There we go. So a little more on the consequences of incivility. This job, the job that we have as lawyers, is hard enough. And you can have a career. And one thing I always say, I do a speech every year for the University of San Diego pre-law students as they get ready to go out on their job, to go off to law school. And one of the things I tell them is this job is hard enough. Being a lawyer, it's taxing, it's very demanding, but you can either do it the hard way or do it the easier way. And the easier way is to be civil and have good relationships with people. But if you don't and you do it the hard way, studies have shown that you're twice as likely to suffer from mental illness and substance abuse than people in other professions. And 95% of respondents in a recent study actually reported that incivility made the practice of law less rewarding and more stressful. Some of the materials you're going to get afterward include an ABA article about civility that talks about more of these issues.
Okay, guys, I do not like to give bad examples of attorney conduct and not give good examples,
But this is a good one.
complimentary good examples. You can see the very mean-spirited judicial officer, judge in this picture, and you can also see the victim of the judge with his hand on his forehead in the other picture. Back in the day, we used to have all of our motions done in one courtroom in our old courthouse, and it was run by one judge. I walked into that courtroom one day to a very packed courtroom, tons of lawyers in there. And as I walked in, I heard this young lawyer pleading to the judge, to the court, for a continuance. The lawyer explained, I made a big mistake on the case, and it's going to prevent us going forward with the trial. I simply cannot go for the trial without repairing this mistake. And I asked the court for a continuance of the trial. The judge was on a rampage that day, and he took the opportunity, perhaps trying to educate or scare the other lawyers in the gallery, to torture this guy for about 10 or 15 minutes on how could you possibly make a mistake like this, and why should this court stop the world just because you made a mistake. And it went on, and the poor lawyer, when he had a chance, would break in and say, Your Honor, I acknowledge I made the mistake, but I just can't move ahead with the trial at this point without addressing it. And you can see by this picture, that's not really him, but I chose a picture that captured his mood. He was almost in tears, and there you could cut the tension in the courtroom with a knife. And lo and behold, the lawyer stood up from the other table. This is sort of what Doug Reynolds looked like. He'd been in our community, legal community in San Diego for years. He was erudite. He was an icon of our legal community. He was intellectual, calm, and understated. This is a man who never used a note. He didn't bring notes to trial. He had it all in his brain. And here's what he said to the judge in this circumstance. He said, "Excuse me, Your Honor. I have been practicing, as you know, in this community for more than 30 years now. And I can actually remember times when I find myself in the same predicament as opposing counsel. I mean, I've made similar errors and I've needed the court's help. I really think it would serve us all well if you granted his request for a continuance." Now, I've talked about this to other people before, and usually I get all teary because it was such an unbelievably professional moment and civil and collegial moment that I've never forgotten it. And rest in peace, Doug Reynolds recently passed away. But example number 2 about how do you want to be remembered?
So civility actually can make you a better advocate too. It's not just the right thing to do. It's not just good for business, but it's actually going to make you better at your job. You can be a better communicator and a better advocate. So it's easier to discuss and work over issues when you have a good civil relationship with opposing counsel. It gets much harder when there's a high level of tension. It's hard to get to the heart of the issues when there's so much emotion involved. It also helps narrow the issues. If you're able to work collaboratively with opposing counsel on things like motions in limine. We actually, my former law partner and I actually had a meeting every time we had motions limine filed in a case, and we talk about number one, number two, number three. Okay, number one, you know what? Maybe they're right. Maybe we don't need to bring that issue up. Let's talk about it. So you can narrow the issues. You can focus on the core issues instead of hostilities. And you're more likely to get professional courtesy from the other side. We all have instances where things come up. Whether it's the kid gets sick or, something happens in your personal life and you need to postpone something or whatnot, you're going to get a yes from opposing counsel when you have a good relationship with them and you've been nice to them. Judge Medell, can you talk a little bit about what the staff hears and sees?
I just want to let you guys know that when the lawyers, opposing lawyers, come in on a case, and there is a lot of back and forth about how rotten the other side is and all the bad deeds that they've done, which many times has little to do with the court's business that day, that I do listen to it to screen as to whether there's anything that might involve me. But once I do that, it goes in one ear and out the other. I never remember what the issue was. I never remember that because what usually has nothing to do with the substance of the case. But what I do remember is kind of like when you meet someone that you think you might have met before and you get a little rotten feeling in their stomach. This wasn't, whatever it was not a good interaction with this person. That's kind of what happens when the lawyers return to my case in 3 or 4 weeks. I don't remember what the issue was, but I say, oh no, not these guys again. And that's kind of an impression that you do not want to leave on the judge who's not happy to see you.
Absolutely not. And it's not just what happens in the courtroom in front of the judge, but what you do outside in the community when you're walking to lunch or having lunch or you're talking on the phone where other people can hear you. All of that matters. And the example that I give on that is that when I was externing for Judge Rhodes, the clerk that I worked with, she and I were going up the escalator. The federal courthouse in San Diego is right near a mall. And the second or third level of the mall had restaurants. So we were going up in the escalator and there were 2 male attorneys standing in front of us. I guess it could have been a man and a woman. I don't even remember exactly, but they were talking to each other about an opposing attorney, and they mentioned the name of the opposing attorney. And the clerk looked at me because that attorney was an attorney that was going to be in our courtroom that afternoon arguing a motion in front of Judge Rhodes. And then so they go on to just badmouth the other attorney. They were just talking smack. It was embarrassing to listen to. It was so bad. And then they started making comments about the judge, our judge that we worked for. You better believe that we remembered that. And you should have seen the look on their faces that afternoon when they came into the courtroom. The judge takes the bench. The clerk and I both walk out and sit at the little table next to the judges, and their face just drained because they knew that we were the ones standing right behind them on that escalator. The other thing to think about, and I can say this because I'm not a retired judge, Judge Manel is, but you really have to think about the psychological effect that it's going to have on the judge. If you're combative, you're obstreperous, you're an absolute jerk to opposing counsel, they're going to know about it. And in my opinion, as a litigator, having tried a lot of cases, balls and strikes tend to go your way when you're nice.
Of course, I consider myself a superhero judge, and none of that would ever affect my ability to be fair and impartial and to make the right call.
Well, not all judges are like you.
All right.
So civility also makes you, I'm sorry, I think we're on the next. Okay, so let's talk about what your client thinks. So sometimes lawyers think, well, I have to be a bulldog. I have to be, constantly not agree to anything just in front of my client because my client's going to think I'm weak. Explain it to your client. Explain that it's important to have civility and professionalism in the practice of law. Explain to them that the studies actually show lawyers who are civil, courteous, professional actually end up getting better results. And especially if it's a billable client, it costs less money to litigate a case when you're civil and you're courteous to opposing counsel. Let's talk though about what to do in front of the jury, because those of us who not only litigate cases but try cases, you want to be really careful, right, about what you do in front of the jury. So in my relationships with opposing counsel, we'd often spend time talking about what we did on the weekend, vacations we were taking, what our kids were doing, different sporting events that we'd gone to. We'd tell each other jokes. We, just try to make things good and professional and collegial. Am I going to do that in front of the jury? No. If I'm walking down the hallway and the jury's sitting on the benches outside the courtroom and opposing counsel is walking down the hallway too, I will nod, I will be polite, I will be courteous, but I'm not going to yuck it up. I'm not going to tell jokes in front of the jury with opposing counsel in front of the jury. Now, once we get into the courtroom, I'm still going to be friendly and my normal self with them, but in front of the jury, I always had a very sort of just professional, but not super, super overly friendly demeanor with opposing counsel.
Even to the extent of it serves you well to help the other side out if they can't get their PowerPoint going or they left something. I just want to add something quickly. I remember in a criminal case, I was a prosecutor for 7 years. I sat down after my closing argument and I left my yellow tab on the lectern. And I saw that yellow tab come flying right in front of my eyes. The defense lawyer threw it as a courtesy, of course, threw it at me and just about hit me in the head. And, didn't say a word. I just put my head down and listened to what he had to say, just as an example of how you have to keep yourself under control in front of a jury.
Absolutely. So we have the San Diego Civility rules. I actually love them. They're I think they're kind of unique and interesting in terms of the presentation, but we will attach those as part of our packet that you'll have a chance to look at. So not only is civility the right thing to do, it's good for business, but it also promotes greater career satisfaction and attorney retention within law firms. So my first 7 years of practice was in one of these big mega firms, right? Huge multinational law firm, and we had a lot of different attorneys. And what I learned as a young associate is you need to pick who it is that's going to be your role model. Because we had lawyers in our firm that would just be obstreperous and mean to opposing counsel. And when you ran into them in the hallway, the stories they told were typically, you won't believe what a jerk this guy was. I was talking to him today, da, 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 da. And they go on and on about how terrible some opposing counsel is. Other lawyers you'd pass them in the hallway and they'd say, oh, Joanne, hold on. I got to tell you this story. You won't believe the funniest story that opposing counsel told me during a phone call I had just yesterday, or some crazy joke that his wife pulled on him for April Fool's Day. But the tone that sets and the way that you feel about going to work every day is totally different when you work in an environment where people are friendly and people are courteous and it's a more joyful, happy experience. Happy attorneys actually means better retention of associates and staff as well. So in every single one of my mediations, I do a pre-mediation phone call. I will two, one with each side. And in that pre-mediation phone call, I ask a lot of questions, but one of the questions I ask is, how are you getting along? Or tell me about your relationship with opposing counsel. And I do that for a number of reasons. One is that sometimes in a mediation, you're mediating not just the dispute between the parties, but sometimes there's such bad blood between the lawyers and they're having such a hard time getting along that you almost have to mediate that or address that separately from the underlying dispute that the clients have. But there's one law firm in particular. It's a San Diego-based law firm. It's a defense firm. Every single time I have a pre-mediation phone call that involves that firm, when I'm talking to their opposing counsel, they always say they have a great relationship with the lawyers in that firm. And the management of that firm has actually made a concentrated decision, a very intentional decision to promote civility within the firm, to promote an environment where they treat opposing counsel with respect and empathy, as opposed to being obstreperous all the time. And I actually had a phone call over the weekend with the managing partner because I wanted to learn a little bit more about their experience and the way they've cultivated a culture like that. And what she told me was that they had extremely high retention rates, not just for attorneys, but for staff members and paralegals as well, because it created a culture where people were happy going to work there and people enjoyed their time together. So civility also promotes good emotional health. I talked a little bit about what happens when you have attorneys around you that are positive, that are not telling, downer stories about bad relationships with opposing counsel. So it creates a better environment in the office, but it also makes it less likely for you to take a bad day home from work to your family at the end of the day. Intentional civility, making a decision to be civil, to be courteous, to be friendly with opposing counsel also reduces stress and burnout among attorneys. I loved every minute of my career. Like I said, I worked for one of the mega firms for about 7 years, and then I left there and I started a 2-person firm with one of the other partners from that firm. I love the big firm. I love my small firm. I love what I'm doing now as a mediator. I know Judge Medell does too. But it reduces that. And I wanted to talk briefly about the concept of microsocial interactions. So microsocial interactions are interactions that are, by definition, last less than 10 minutes. Typically, it's anywhere from 30 seconds to 2 minutes. And there was a study that came out recently. My husband and my son are always making fun of me because I can't, and I think you're the same way, Judge Medell.
Yes.
Can't get it into an
Her
elevator.
husband and her son are always making fun of me.
Yeah,
No,
that too.
that's
But we can't get in, neither one of us can get into an elevator without striking up a conversation with someone. So, I'll get into an elevator and I'll say, oh, nice shoes, or boy, that's a nice briefcase or something. And then we start a conversation. Otherwise, you're just looking at your phone or you're looking up at the ceiling, but you start those conversations and here's what happens. It's a good way to start the day. You meet new people. And what I found is I oftentimes would meet attorneys that practice in the same field as me, but they were typically on the other side of the case. And then they'd say, oh, well, I need your card because I'm actually always looking for an attorney that does what you do, and I need someone to send referrals to. And I have a number of attorneys to this day. They're using me as a mediator now, but they would send cases to me. And those were people that I literally met in the elevator while I was going up to my office every day.
I actually do that as a matter of personality, but I think I might do it to a fault because I've had my partner and others who are less social say, do you think you can get on this elevator without talking to someone? So it might annoy, well, it was before I was a judge. It might annoy a few people, but still, I think the general point of reaching out and being friendly toward people, could mean good business. At least it means goodwill. You've made someone feel good in an elevator one day as well as yourself. So, guys, I want to talk to you a little bit about this question. Turnabout is fair play when it comes to civility. I once again had a very serious case involving an injury or death of a baby, and it was a 10-week medical malpractice case. The lawyers on the plaintiff's side were 2 women who were as prepared and more prepared than any lawyers I'd ever tried a case against, even to this day, or seen in my courtroom to this day. Incredibly knew the medicine so well, knew every single medical reference to the subject matter of our case, and really were like encyclopedias of the case, well beyond the actual facts of the case. But they were also highly charged and emotional. And in the opinion of the 3 defense lawyers, I was the least targeted. My client was the least targeted of the 3. We had the hospital, the doctor that delivered the baby, and my doctor had seen the baby had seen the mom when she first came in. to do the delivery. I was the least of the targeted defendants, but every single day for 10 weeks, there were a lot of things going on in that courtroom that shouldn't have been going on. A judge would sustain an objection to the content of a question, and the lawyers would simply reword it and ask it 10 times more, such that we had to keep objecting. This is all in front of a jury. Over and over, they would abuse what I believe the evidence code by reading for 10 minutes a medical text to the jury when then, that was not the way the evidence code was designed to have just someone do 10 minutes of reading when they had a witness on the witness stand. At the end of it was, do you agree with that paragraph? Or do you agree with those 4 pages that I read, to their expert or to on cross-examination? They would tell us the witnesses that were supposed to appear tomorrow morning from the plaintiffs, and then they would come the next day with 4 different witnesses. And daily, they would accuse one of the 3 of us of some ethical impropriety that we supposedly did. I was lucky because mine happened at the very end when I think they must have said something like, well, we really haven't targeted Ken on this yet. And they came in and claimed that I had inappropriate contact with a treating physician. In short, it was 10 of the most tense and miserable weeks that I've ever spent. And to their credit, they got a good verdict. And this is at the very end of the case. One of my colleagues, my 2 defense lawyer colleagues, called me up on a Friday. In San Diego, as you guys might know, we have trial Monday through Thursday, but not on Friday. And this lawyer called me up and said, we told the plaintiffs that we were going to call 4 witnesses, but I'm talking to the other lawyer and we decided just to call 1 and not tell the plaintiff's lawyer. Now, the net effect of that would be that the plaintiff's lawyer would be working on cross-examinations all weekend while we would be working on closing arguments. And we would show up on Monday and say, we didn't call these 3 witnesses, we're ready to do closing arguments, and catch the plaintiff's lawyer by surprise. But once again, we had a discussion. I said, both of us were lucky to get into ABOTA, and we've been in the American Board of Trial Advocates for many, many years. And one of the criteria that got us in was our commitment to being civil, collegial, which includes being open, honest, and not doing these kind of dirty tricks. And suffice it to say, by the end of that telephone conversation, we had said we need to distinguish ourselves from the dirty tricks that have been played against us by never doing that, by rising above that and doing the right thing. And so upon that agreement, we called the plaintiff's lawyer and told him, well, we're not going to call 3 other witnesses, and life went on. I'm not sure there was any specific reward. Maybe the dear Lord is looking down on that, but
Well, you feel better about
but we felt better about ourselves, and we felt better about our commitment to the standards that ABOTA and just being a good lawyer imposed on us. And that is civility, collegiality, openness, and honesty.
Speaking of ABOTA.
Yes.
Yeah. So civility can help with career advancement. You're a member of ABOTA, aren't you?
Yes, I have to say I was on the membership committee for our chapter of ABOTA here in San Diego for many, many years, and I don't know why it happened, but I got the hardest cases to evaluate on new candidates. And they would, and here's why they were hard. Here's what it would sound like. I'm calling about this particular lawyer. You tried a case against them. What did you think about them? This is about their membership effort for ABOTA. I'll tell you what I think about them. I don't think I've ever seen anyone command a courtroom like this opposing lawyer before. This person knew the evidence code back and forth. His cross-examinations were amazing. He reduced my expert to a shriveling rubble on the witness stand. And to this day, as I lie in bed, even though that trial was 3 or 4 years ago, I can still hear the words of his closing argument ringing out. They were so powerful, and he wiped me out. This guy is truly deserving, given his trial skills, of being in ABOTA. I would say that's fantastic. Well, that's criterion number 1. Let's go to criterion number 2. What do you know, or what did you experience about his civility, professionalism, and collegiality? And typically that would be, do I have to answer that question? And I'd say, well, you don't have to, but it would really be helpful. And after a lot of resistance, I would finally get them to say what they were feeling, and which is, no, this guy, he hid every bit of evidence that we possibly was produced. I had to do a motion to compel on every single routine piece of evidence. He actually had one of my witnesses was an 89-year-old woman. He made her cry. He was so brutal in terms of the cross-examination. And there was just a lot of things that were dishonest about the way he approached the case. I cannot give him good marks for collegiality. And in Aboda, that was enough. If 2 or 3 people said that during our investigation, you were done, at least for now. You could make efforts to correct that as time went on, but for this particular application process, you were done if you didn't get good marks on either one. I will ask you, if any of you wish to become a judge, you really, really need to behave in an appropriate way. I don't know if this sounds self-congratulatory or not, but I really think that legal skills and trial skills and all that stuff were not the propelling force to make me become a judge. I believe the fact that they sent out 500 evaluations, many of them to my opposing lawyers on cases, and that people said, one thing you could say about Ken, we really had a lot of fun with that case. We've really become close friends afterwards, and I think he's great. I think he'd be a great judge. I think those comments made me a judge more than any legal skill or acumen. And so, and if you don't have those, if too many people say the wrong things during your judicial evaluation, you might as well say goodbye to that opportunity.
Absolutely. And not only that, but also building a network for future jobs. You may love the position you're in right now, but you never know. The folks at Roback years and years ago probably all loved their job at Roback, but it's no more. And so if you have good relationships with opposing counsel, it's going to increase the likelihood that you can land on your feet if you have an adverse job situation come up. Why don't you talk about the dentist office case?
Guys, I'm sitting, I was in a big firm. We had 50, well, for San Diego standards, we had 55 local lawyers in our firm, and it was an insurance defense firm, so we did every kind. I was lucky to do the medical malpractice stuff. I'm sitting in my office minding my own business when the receptionist said, Ken, there's a guy here to see you. He wants a lawyer here to see you. And I said, what's his name? And they told me his name, and I go, I don't know anyone by that name. And she says, well, he says he has a case with you. And I finally went, okay, this is before telemarketers and stuff, people showing up. So I said, send him back. And he came back and he introduced himself. And he says, you may not have the materials for this case yet, but I am a plaintiff's lawyer and I have a case that's coming. And I've been told it's coming to you as one of 3 or 4 different defense lawyers for different parties in the case. And I was in the air. I just wanted to come by and introduce myself. He introduced himself. He told me about the case. He told me that his client was, I think she was like 23 or 24-year-old woman who was born with a genetic disorder that made her look very tiny, very disfigured in terms of her orthopedics, as well as her face, and very, very reticent and shy. And at age 23, she asked her mother to take her to the dentist's office, having not been there for a long, long time. In the dentist's office, the dentist looked at the inside of her mouth and said, she has a really, really, really bad collection of plaque all through her mouth, and she'll need for us to do the cleaning procedure. But he said, and this is the important part, for patients like this, it's best that we do it under general anesthesia. Knock her out. And what did he mean by patients like this? He thought she was mentally disabled, whereas she was not. She was completely normal. He puts her under the general anesthesia. As soon as he touches any one of her gums, blood just comes spurting out. The blood pooled in her throat. Something called laryngeal spasm, which is her throat just locking down, happens. And she begins to suffer hypoxia as they dial 911 to have an ambulance come in and take her to the hospital. At the hospital, she's intubated. And 2 days after that, the nurse walks in and she had extubated herself. So she'd removed the breathing tube. So now the hospital gets sued. I believe I represented a pulmonary doctor that was involved in that process. And he explained that this was the case to me. But more important than explaining the facts of the case, he said, here is what's going with her now. Here are all her treating doctors. Here is what her status is right now. Here is a list of the doctors if you want to start subpoenaing their records and the rehab places and that sort of thing. And by the way, in terms of prioritizing who I'm going to target, your guy is about three or four people down. You're not going to be the target. But if there's anything at all that you need from me to help you get acquainted with this case, just consider me a resource. I'd be happy to provide you the medical records, for example, just by sending those to you. I hadn't had the case yet. I knew there was something coming down, but I had nothing about the case at this point. And that was the first time ever that I'd have anyone come in and in such a calm, professional, and ingratiating way introduce themselves and offer to work together with me in such an amazingly collegial way toward arriving at a just result in the case. I've never forgotten that. Oh, by the way, here he is. This is Charles Lamandry. He was the.
We're gonna name names now.
Well, name names are the good examples, but he was the man who did that. I just want to give you that as an example.
That's great.
There you go.
So how do you build good relationship with opposing counsel? Not all of us are going to be a Tom to walk into someone's office and say, hey, I'm here. I want to talk to Judge Medell or Ken at the time. My practice was if I had a case with an attorney I'd never been opposite before, the first thing I would do once I found out who the attorney was is I would give him a call. And I would call with no agenda, no, nothing I needed to, no extension, nothing like that, but just to introduce myself. And I would say that I enjoyed having good collegial relationships with all of my, or almost all of my opposing counsel, because as we'll talk about in a little while, you can't control everyone. But I said I have good relationships with opposing counsel. If I ever do anything that you think is just totally, I've gone off the deep end, what the heck is Joanne doing? Call me, let's talk about it. And I'm a big fan of picking up the phone or better yet, meeting in person. I actually did what I call discovery lunches. So when I had opposing counsel and I had a discovery dispute and I knew it was going to take us quite a while to go over stuff, I would actually call the other lawyer and say, hey, let's grab lunch. Bring your notes, I'll bring mine, but let's grab lunch together, and my treat. So we would get together, we'd have lunch, and I intentionally didn't introduce the discovery issues or even the case at all until we were done with our meal. I would just talk about, where'd you go for your last vacation, things like that, just to get to know each other. And then after we finished eating, I'd pull the papers out, they'd pull theirs out, we'd talk over the discovery issues. 99% of the time when I had a discovery lunch like that, we were able to resolve the issues. And we know how much judges love discovery disputes, don't we?
Yes, they're so much fun.
Yes. Another thing I learned very, very young very early in my career was never attack opposing counsel. So when you have, whether it's in writing or you're standing up in the courtroom in front of the judge, you don't attack the attorney. You don't say, well, Attorney Joe says this, or Attorney Joe is doing this, or whatever. You say, the defendant, Big Co or Jane Doe or whoever asserts this or whatever, as opposed to the lawyer, because what we're really doing is our clients are adverse to each other. We're not adverse to each other. Another idea is obviously join it in a court, attend the bench bar mixers. I drove up a couple of weeks ago to the Beverly Hills Bar Association installation dinner, and it was just wonderful to see all of you guys interacting with each other and even with opposing counsel, sharing a beverage together, sharing a meal together. But you can volunteer too. San Diego County Bar Association does beach cleanup days where we go out and we pick up trash on the beach. But do that sort of thing to build relationships with lawyers outside of your cases. So let's talk about, I mentioned that you can't, you're going to have bad apples. You're going to obviously have people that are absolute jerks to you. And what do you do when you have someone for example, in a deposition that is just obstreperous, like the attorney that Ken mentioned earlier. So I would say take the superhero high road, first of all, moderate your tone. This works for lots of settings, not just legal settings. But there's an acronym, and I'm going to give credit where credit's due. There's a mediator trainer named Bill Eddy here in San Diego, who his specialty is high conflict personalities. And he developed this thing called SLIC, S-L-I-C. And it basically is set limits and impose consequences. So for example, you have a deposition where they're coaching the witness, like Judge Medell explained, or they're interrupting your questions. And they're just that kind of lawyer, and you're not going to be able to retrain them in the moment. You need to just basically lay down the law by being firm, professional, not emotional, being professional and basically saying, you keep interrupting me. I don't appreciate it. It's not appropriate. If you do it one more time, I'm going to have to suspend the deposition and seek a protective order. So that's the SLIC technique. Let's talk about what to do when you get a nasty gram. We've all gotten one of these. So let's say, for example, you get a situation comes up and you have to postpone a deposition. Let's say your secretary sends an email to opposing counsel, says, we're really sorry, but that deposition scheduled for next week has to go off calendar. And opposing counsel immediately sends you a nasty gram, 2-page single space email that basically is going over and rehashing, ranting and raving, going over every perceived wrong that they think you've done wrong in the case. They demand at the end of the long ranting and rave, they demand that you reset the deposition. So your knee-jerk reaction might be a point-for-point counterpoint letter or email, right? Going back and saying, no, you're the jerk, and you're the one that did this, and you're the one that did that. But what does that do, right? It ratchets up the dispute instead of calming things down. It solves no problems at all because you still got this deposition you got to take care of. And third, it costs a lot of money. You might spend 2, maybe 3 hours working on that really nasty response to them that's really not going to do you any good for your client. So what you can do instead is use another Bill Eddy technique called the BIF technique. So what is BIF? It is a response in writing that is brief, informative, friendly, and firm. In the context of the example that I just gave you, what you would do instead of doing a 2-page single-space ranting and raving email back to the other side, you send them an email that's 1 paragraph long. You start off, and this is the friendly part, good morning, or maybe even if you're willing to go there, I'm sorry. Explain the reason, you know, I'm good morning. I'm sorry that I had to postpone the deposition. My wife had a surgery scheduled, and that day was the only day the surgeon can do it. So I had no choice but to postpone it, offer alternative dates, thank them for understanding, and tell them that you hope to enjoy a professional relationship going forward. So what's the effect of that email? You've completely diffused the situation. You took the high road, you didn't sink to their level, and you resolved the issue. You gave them alternative dates. So that was a perfect example of brief, informative, friendly, and firm. You're going to have a much better outcome if you do that.
And they might start calling you Biff.
Okay.
They might start calling you Biff. What was the other one? The other acronym you had?
Oh, SLIC.
Yeah, so
Slick
either
Biff.
Slick or Biff. You might have a whole new identity.
You're
just don't
Slick Biff.
go yet.
Okay.
I want to just, since we have, we're almost done here. I just wanted to add a few more comments to this particular subject matter we're talking about. If you've been in my courtroom, you may have heard me. I wouldn't call it a rant and rave, but it's a minor complaint by a judge about modern day meet and confer. Here is modern day meet and confer. Someone doesn't respond to your discovery properly. You immediately go to your computer because you have an obligation under the Code of Civil Procedure to meet and confer. By the way, meet and confer means meet and confer and try to solve the problem, not just meet and confer. But you go to your computer and you put down not only all of your complaints in terms of the lack of discovery response, but you put down all your emotions too. This is like the 10th time that you've done this, and all the different things. And you don't realize what you're doing is very much like Moses coming down from the mountain with principles inscribed in tablets that cannot be removed. Here is my position. And you know what your opposing lawyer does? He goes, oh yeah? When he gets your letter, he gets on his or her computer and does the same thing and has his independent tablets, Moses's tablets. Both of them can't be changed because they're inscribed in there. And it's just the opposite of meeting and conferring and trying to solve the problem. So as Joanne mentioned, I really, really favor the old school way of doing it. I started doing civil in 1987 after 7 years at the DA's office. And back in those days, you just called up the person, or on occasions, you'd meet them for lunch somewhere, and you would go over what it is exactly that you were shooting for in your discovery. And the opposing lawyer, who was supposedly the bad player because they didn't answer it, would say, oh, kind of like Pulp Fiction. Oh, you didn't tell me you were sending the wolf. That's a whole different story. They say, oh, is that all you want? I can do that. You don't know how many times in informal discovery conferences in my courtroom where that happened, where they got all dressed up, they got their tie on, they came down with all these papers, and I just go, when you asked that question, what were you shooting for? And they tell them, and the defense lawyer says, oh, I can do that. And in 10 minutes, we've solved everything just because you guys couldn't communicate yourself in an old style communicative way and express that directly on the phone or in person with the other side.
Well,
That's meeting and conferring and solving the problem.
right. And I've actually experienced as a mediator sometimes, you wrap up a case, you get the case settled. I always tell people to circulate a draft settlement agreement in advance, because if we have a resolution, I want a signed agreement at the end of the day. That is absolutely the best thing to have. I mediated a case years ago now where the opposing counsel or the lawyers did not circulate a draft settlement agreement. They said, oh, don't worry about it, we'll get it done afterward. Literally 8 months after we settled the case, I got a call from one of the attorneys saying, we still don't have a signed agreement because we're fighting over the terms of the settlement agreement. And what they were doing, the issues, I jumped back in to help them resolve it. And what it was their emotions were getting in the way. They were fighting, it was just ratcheting it up to the point of being ridiculous. The actual substantive problems with the settlement agreement were tiny. So
yeah, I would say that not only approaching a meet and confer in that sort of collegial way, calling up or meeting with someone, but also Joanne and I were talking about how it can lead to bigger accomplishments. I had a gentleman in my, a guy that I love that's in my building who's one of the few plaintiffs medical malpractice specialists in town. And we had a big case against each other. And I called him up and I go, Bob, his name is Bob Vokey. I don't mind saying his name, I love the guy. But I said, Bob, I think we need to go to mediation on this because I know you have really strong opinions on this. I have really strong opinions. I don't know if we can do this on our own. He goes, Kenny, I'm 3 floors above you in this building. Come on up, and let's talk. We went up there, and of course we talked about the thing that was most important, baseball, for 50 minutes. And in the last 10 minutes of our hour-long discussion, we settled the case. Same thing with a guy named Ben Bunn, who was a very young man at the time, but is now the president of Araboda. I called him up on a very serious case and told him, my client has no insurance. And at the end of this case, I will own everything that he has. You will get nothing because he doesn't have anything. I think you should take action right now. And we met at a breakfast place called the Mission Hills or Mission Breakfast over in East Village, and we settled that case. This is what face-to-face collegiality can accomplish. And this is why we put on this presentation. And this is why I will say to you, how do you want to be remembered, for God's sakes? This person, the slip and fall in the hospital, that lawyer? Or do you want to be remembered more like Mr. Lamandry and Mr. Reynolds and have me look at you 30 or 40 years later and have such a good feeling and a warm remembrance of our interaction? And I think with that,
I think we've done we have run out of our stuff, but we are here if you have any questions.
are there any questions? Maybe Min can help us with that.
Yeah, so we do have a few questions. The first one is any suggestions for managing the client expectation that bulldogging and being aggressive is not compatible with civility?
Absolutely. So, and I've had clients who had said, it seems like you're best friends with the lawyer, like you're really friendly with them. Like, shouldn't you be, more aggressive? And what I tell them is, advocacy is not the same thing as you don't have to be a jerk to be an advocate. And the reality is that if I have a good relationship with that opposing attorney, we're more likely to get what we need in the case, whether it's a postponement because your kid got sick and you can't make your deposition, or it might be, we might get a better result at trial, or we might get a better settlement because the attorney is willing to talk to his client about the fact that, well, Ms. Rezzo actually takes cases to trial and she's good at what she does, and the judges and the jurors like her, so it actually works to your benefit when I do that.
There's a certain number of defendants, and that included my doctor defendants when I was doing medical malpractice, who don't want you just to defend them. They say, how can we get back at them? What can we do on the affirmative attack to get back at these people? And it does take a lot of patience, a lot of time you spend with your client, indicating what's possible and what's not possible, what would be the most effective way to defend you first, and then we can think about other things. But to explain who you are and what you intend to accomplish and how, and hope that they understand that that's why we are where we were. I think that's the only thing you can do is explain it to them calmly. There will be a certain percentage of clients who just won't accept it, might think you're too weak, but hopefully you've built up a little bit of a reputation in town where you can say, check with these other people, and they'll say, no, this guy wins everything by honey, not by what's the other thing?
I don't know. I only ever use honey. I don't know what the other one is. Ren, did you have any other questions for us?
Yes. So this one attendee says, I have had good relations with some opposing counsel. Others have gone out of their way to be difficult. Others do not seem to think that civility is part of the role. What I was hoping to get from this course were some suggestions on how to deal with difficult opposing counsel, how to lower the temperature so you can discuss the facts and resolve the issues for your clients.
Sure. So I think that question might have come in earlier in the presentation, but again, think back to the BIF and the SLIC techniques. If it's in writing, what you want to do is keep it short. Keep your response short and professional. Be like a duck. Let the water go off your back and just respond in a professional way. And that diffuses the situation instead of ratcheting it up. And again, if it's a oral deposition or oral conversation, you need to use the SLIC technique, right? Set limits and impose consequences, and basically say, you're doing X, Y, and Z. I don't appreciate it. If you continue, here's the consequence.
Right.
All right. So this question is, what can be done when the judges refuse to hold opposing counsel responsible for bad behavior, including lying and refusing to follow court orders? Does the judge have any responsibility to hold attorneys accountable for their behavior in a case?
Well, it just depends on whether. Let me give you an example of something that I say to jurors all the time when I'm choosing a jury. I try to explain to them what a cause of action is, and I tell them, my court reporter could stand up right in front of all you people and say to me, Judge, I've never seen you looking so ugly and miserable today. And if she said that, that would be morally wrong because she's embarrassing me in front of all these strangers that are in my courtroom. And it's just mean-spirited and wrong. But I would tell the jurors, but there's no legal theory that covers that. It's not a bona fide cause of action. So we're not going to deal with all the wrongs. We're going to deal with only the ones that the law reflects, that the law supports. Well, it's the same thing with lawyers misbehaving. 90% of the time, it's a misbehavior that the court can address because it falls within the rough, unstructured categories of professionalism, civility, and collegiality. You violated those things, and you say, well, I know, but you didn't violate anything that the court can really remedy. So the brief answer is, if it is something that's, for example, a bona fide discovery abuse, if it's direct lying under oath or direct lying to the court, you know, I would hope that most judges would take that seriously and conduct a proper inquiry into it and sanction when sanctions are appropriate. But there's many complaints that the two lawyers have with one another that just doesn't fall under anything that I can deal with. I hope that's not a cop-out answer, but that is the answer.
Well, and I think as a litigator too, one thing to do is make a record of what's going on. You know, if something's happening in a deposition, for example, that's not on the record, make a record when you go back on into session in the deposition. Or if something is said to you that's unprofessional or uncivil, you know, you can make some kind of a record of it to you know, address it later if you need to.
You know, as I was driving here today, I was thinking about that case where the lady slipped and fell in the hospital and thinking, what could I have done? I mean, was I at fault in part for letting it go for 8 hours when it shouldn't? And as you move through your career, you learn how to deal with these things. For example, in retrospect, I would have stopped the deposition at 4 hours or given him a good solid time to do what he wanted to do. And then I would have gone to court or asked him, I want to retake the deposition, but I want to videotape it this time, the rest of the deposition. Because I did have, in that other case that I talked to you about the injured baby case, I got in late and I had to retake the plaintiff's deposition, and so many bad things that were happening there that I did terminate the deposition and go to court and say, here are the things that the interactions between the plaintiff and their client that are just totally inappropriate for the deposition. And you know what the judge said? Well, I can't see that. Same as what Joanne just said. I can't see that in the deposition transcript. So I recommend that you go back and you videotape it. And that's what we did. We videotaped it. And now you have hard evidence of impropriety captured on film. So that's going to help you a lot.
Rin, did you have any other questions?
Yes, just one final question. Is there ever a time or place to report an attorney to the state bar if the conduct gets so far beyond the line?
Ah, well, now you have to. If it goes to the line of true misconduct or criminal behavior or that sort of thing, I think there's a new statute that requires you to report it, even if it's a colleague, even if they're on your same side or your same firm, for God's sakes. So, but Joanne, you want to?
Well, no, you can report things to the state bar. And you don't want to go there with every kind of tit for tat that happens, right? And one of the things, my former partner, Chip Edelson, was an amazing mentor, and I learned so many things from him practicing law with him. But one of the biggest lessons I learned with him is pick your battles, right? Because not every dispute, not every fracas needs to continue. I mean, sometimes you just say, you know what, I'm gonna let that one go. It's the same thing when you're driving your car on the freeway, right? You know, someone cuts you off and you can get right on their bumper and you can honk your horn or you can salute them, or you can just go, you know what, karma's gonna get you.
I would say that piggybacking on what Joanne just said is it really would have to be something egregious to really warrant you contacting the state bar. You know, that's my comment, and that's just an opinion, meaning not a judge's opinion, just a human being's opinion. So everyone's got to approach it in your own way.
Well, thank you all for attending, and Rin, we will let you sign us off.
How do you want to be remembered? We'll see you guys.